In Ontario, as well as all the other provinces in Canada, that puts you in the strongest possible legal position you can be in as a litigant before the courts in this province, as well as all the others, being a non-cause dismissal. The employer is required to indicate the actual reason for dismissal, such as if they accused you of being late, perpetually late, or misconduct, or intoxication, and they haven't done it, and more or less it's too late. They can come up with something after if they have good evidence. That means that the question that we have to ask ourselves is not if you're entitled to further severance, but how much. And which is a good place to be in terms of your ability to negotiate with the employer, which of course we can help you with. What your rights really are, once again in all the provinces, including Ontario, are based on three main factors, being your age, your length of service, and the type of position, all to be determined or assessed as to how long, with those factors, it's going to take you to find another position. That's what we call your common law entitlements. And based on all those three factors, we use a base of 1 month per year of service as sort of a rule of thumb, but we'll increase it and decrease it based on those factors and a combination of others, such as whether or not you have a position which is highly technical, whether there's a managerial position, whether you're in an industry area such as IT, where it's very important for someone, not important, but generally speaking, it's a young person's industry. These are all factors we look at once again to determine, usually with the help of vocational analysts, to determine how long it's going to take you to find another position. Well, the good news is that the law requires the employer to pay, commensurate with your employment, all the benefits that you enjoyed while you were employed there, making you whole, as we say, putting you exactly in the same position you were as when you were employed. And that's what we would be doing in terms of your general severance package. So if you had a dental plan, if you had a long-term disability plan, which generally could add up to at least 15% in value of your total income, including commissions, including bonuses, we would be in a position to negotiate a package which would be comprehensive in nature and include all those things, and the valuation, of course, would be a great deal more, as I see it, than the minimum severance and notice that they're offering you now. In addition, we would always negotiate an outplacement or training package for you, as the law requires, especially if you're engaged or intend to retrain for another industry. And we'd require them to provide you with, if not a positive letter of reference, the law doesn't go quite that far, we would require them to provide you with a confirmation of employment letter, something positive, which would give you a fighting chance to obtain another position. Because really that's what we're about here, trying to negotiate you a bridge, a financial transition, in order for you to obtain that next position. You have many years left of your career. We would attempt, and I would believe successfully, to provide you with a financial bridge in order for you to obtain your next position in your career. That's the goal.